For today's story, we turn ourselves to the Army Court of Criminal Appeals as we deal with the discipline of a military member as it relates to potential assault of a more sexual nature and questions about whether we can use prior acquittals as evidence of guilt in a new case. So this person has been charged before for various offenses, but these various offenses have been found, we've been found not to have done the thing, right? So we found not to do the thing in the past, and now we're being charged with kind of the same thing. It's like, okay, so can we use the past thing that we were acquitted for as part of a pattern for the new thing? It's like we weren't able to prove it into its own right, but we'd like to show that it was part of a pattern of conduct that helps to amplify this charge. So can we use a prior acquittal as evidence of guilt, at least in terms of Army discipline? Let's get started with this. In the case of U.S. versus Henderson, decided by the Army Court of Criminal Appeals, the court reversed the defendant's conviction for forcible conduct against a woman. Well, we use the term woman loosely because the person was 15 years old at the time. So we were convicted of the assault against the 15-year-old girl, but how about not so much with the guilt? And here is the court's rationale for reversing the conviction. Before the trial, the defense filed a motion to exclude a military rule of evidence as similar crimes relating to these kinds of cases. There's a special rule for it in the rules of procedure, by the way, in both the civilian system and military system when it comes to offenses involving this kind of misconduct. So there is a rule dealing with misconduct in general, but there's a special rule dealing with misconduct of this special nature. So that's Rule 413. The military judge denied the defense the motion regarding the victim writing, other than the fact of acquittal and assertion that the sworn statement to police was contradictory to the statement's report. No exculpatory evidence was presented to this court for consideration of matter. So they's like, okay, I've been acquitted of things in the past, right? So I've been acquitted of the past, and there's a contradiction between what I said happened and what the victim said happened. So this is what I have. And the court says, okay, other than that, there's no exculpatory evidence. Despite the obvious reasons that this factor, the intervening circumstances, may weigh against admissibility as asserted by the defense, the government argues that when considering the charged offenses occurred after acquittal, the appellant's tactics were emboldened and this factor weighs in favor of admissibility. The court finds this factor to be neutral. So we'd like to admit, these things in the past where there's issues relating to previous acquittals. So can we do that or not? This court writes, with respect to the rule, the military judge told the panel, you have heard evidence that the appellant may have committed another offense, that is, evidence pertaining to this victim. The appellant is not charged with that offense. You may consider the evidence of this other offense for its bearing on any matter to which it's relevant, including its tendency, if any, to show propensity to engage in offense. So you can use the acquittal to show propensity to commit this crime. And you can kind of see the issue. You have heard evidence that the appellant was acquitted of the offense in a prior court-martial. You should consider that result, but it's not binding on you. So he was acquitted in a prior court-martial of the forcible interaction with a girl. And now this court-martial, it's like you can consider the fact and you can use it as indication that he has a tendency. And they might have acquitted him, but you're not bound by that decision. So you can see how well it's going over here in this court right now. The prosecutor argued, among other things, that in May of 2018, the appellant was acquitted. He learned from those mistakes in many ways because the victim was not the perfect victim. Yes, she was easy to physically manipulate, but mentally she was 18, almost 19, and equal, a peer of the applicant, intelligent, early college courses while in high school, an award from NASA, a software engineers. In many ways, she was the wrong victim to choose, and appellant learned. Because what did she do? She immediately ran home to her mother, who was watching out for her, and told her what happened. Immediately that night went and got a sexual assault forensic exam and told the police, and there was a trial, and he was acquitted, and he learned. So apparently the prosecutor would like to use the idea of, aha, he's a previous person who, this victim, tried to do everything right, but he was acquitted anyway. So he learned from his mistakes. He learned from his mistakes because, this victim would be perceivably pretty credible, right? Early college courses, some sort of thing from NASA, all the rest of it. So this should be a pretty credible witness. But he learned from his mistakes by his second choice of victim, by picking a 15-year-old runaway who has an alcoholic problem and drug dependencies issues. Who's going to believe her, right? Who's going to believe her even if she does come forward? They didn't believe the victim that, with the NASA thing. Why would they believe this victim? She was a more perfect victim. They didn't believe the other victim. Why would they believe this victim? So yeah, so we want to use the fact that we committed the other crime except we were acquitted and said, okay, well, this person who we sexually assaulted was bright, intelligent, went right home to their mother, got a sexual assault kit immediately, did everything that you kind of should do, in sort of an idealized world, everything we tell women to do. But, for whatever reasons, he was acquitted. I assume because the issue came down to consent, one would presume, about who consented to what, right? And so it's like, okay, he learned from his mistakes because, he came too close to being convicted. So rather than pick, the early prodigy with the early college classes and the NASA thing and all the rest of it, he picked a 15-year-old runaway with the alcohol issues because he wanted to make sure that he had a less credible witness against himself. So he learned from his mistakes. He learned. So he got acquitted before. Don't let him get away with it again. So this is how well it's going over here in Army land. The court held that the court below, allowing this argument, violated the defendant's rights. So the Army Court of Appeals is over here saying, you know what, trial court with the court-martial, this is a problem with the court-martial. You are trying to use a person who was acquitted. He was acquitted of the sexual assault. And you're trying to say, aha, he was acquitted. That makes him all the more guilty. Yeah, we're not really buying that over here in appellate court land. So not so much with your court-martial. No. So the Court of Appeals writes, subject to 3 threshold requirements, the rule permits in a court-martial proceeding for a sexual offense, a military judge may admit evidence that the appellant committed any other sexual offense, which incidentally, there is a parallel rule in the civil system, or in the civil criminal system, I should say, in the civilian. How about that? The civilian criminal system. There's a parallel rule. So this isn't just a military thing. There's a parallel rule in the civilian system too. So normally you can admit evidence of other offenses. It is propensity evidence, but there's a special rule for it. They created a special rule for it because we were that concerned about those kinds of cases. The threshold requirements for admitting the evidence are that the appellant must have been charged with the offense of assault. So first of all, it has to be something they were charged with. Second of all, the evidence must be evidence of commission of another offense of sexual assault. So that evidence occurred, and the evidence must be relevant. The court continues. There is a need for great sensitivity when it comes to determination to admit evidence of prior acts that have been subject of acquittal. One would imagine, right? So these are acts that have already been fully adjudicated. And the girl came forward and said, I was assaulted. I went right away to the hospital. I got the sexual assault kit done right away. I did everything. And the court-martial said, how about not guilty? Okay. So they did that, which, they do. When dealing with the problem of considering acquittal in weight of probative evidence of propensity, that is, it's more likely that you did this thing because you did other things, even though you're acquitted, right? Against unfair prejudice that might result from the admission, there's an expectation that judges deal with the admission of evidence previously, the subject of an acquittal charge, very carefully. A military judge who admits such evidence must carefully instruct the panel that they were acquitted on the charge of the same allegation and necessarily to consciously limit consideration of the evidence accordingly. So even if you can admit it, it requires a greater cautionary instruction than was provided at this trial. The Court of Appeals for the Army continues writing, The acclamation of error started with the military judge's decision to omit the evidence regarding the victim, though her allegations had led to an earlier acquittal. In the analysis, the military judge credited the government's theory of inference that one could draw from the earlier result. Writing, so this is the court-martial judge writing, the government argues that when considering the charged offense occurring after acquittal, the appellant's tactics were emboldened, and this factor weighs in favor of admissibility. So yeah, the court-martial judge was all about it. The military judge who was doing the court-martial did not question whether this proposed inference was logical or lawful. Instead, he placed it on the scales as counterweight to defend its opposition to the evidence. The inference was not permissible for two reasons. First, the acquittal was not legally relevant to the issue of appellant's state of mind. So, as to what this defendant was thinking, when or if this sexual conduct occurred at all, because of course that's also subject to dispute because we're in a trial, right? So assuming it occurred, assuming the conduct occurred, what was the state of mind? And this prior incident doesn't go to his present state of mind because, yeah. Using our common sense of knowledge of the ways of the world, we might recognize as acquittal might embolden one to commit future misconduct. So the fact that you're acquitted makes you more likely to commit crimes in the future, I guess. So heads I win, tails you lose, I guess, when it comes to criminal trials. On the other hand, our experience and knowledge also tells us that acquittal is at least as likely to encourage other behavior, including the avoidance of anything unlawful. So yeah. So maybe it makes them more emboldened. Maybe it makes them more scared, right? Because, man, I came so close. I came so close. Maybe I should mind my P's and Q's. So it kind of could go either way. Yeah. Viewed in this light, an acquittal does not create a tendency to make further misconduct more or less probable. It is not the case that acquittals necessarily tend to embolden people. It might embolden some people, but as to other people, it might make them fly high and straight, right? It's like, man, I came so close to that conviction. For the sexual assault, I came so very close, man. Damn. I can't believe how close I came. I'm going to leave a really, clean life from this point on because, man, oh, man. So the court is over here like, we're not sure which way that you can say this goes as a matter of tendency. So you can't argue that it has a tendency because it doesn't. Even assuming the relevance for the sake of argument, evidence of the prior acquittal as used in this case does not survive the required ruled balancing test. Weighing the probative value of the prior victim's testimony against the risk of confusing the issue and creating a distracting mini-trial, relitigating appellant's prior acquittal and potentially misleading the members does not favor admission. So, when you brought on the prior alleged victim and put her on the stand in this case, right? Hey, prior victim, would you like to testify in this case? Yes, I would. But I was acquitted. Yeah, that just makes you all the more guilty. Let's hear from the prior woman again. Let's hear from her again about the bad things that happened to her. And hey, current court-martial, the fact that this guy was acquitted and the previous jury, didn't convict, that does not bind you. So how about a second go? How about would you like to believe this victim's story as it relates to the conviction of this new woman? Anyone seeing the problem? Apparently the court-martial judge did not see the problem. The Court of Appeals for the Army sees the problem. Secondly, the inference is not permissible because it violates the Constitution. Oh yeah, that pesky thing. The Constitution's due process guarantees that a person shall be presumed innocent of a charge, unless and until the government proves guilt beyond a reasonable doubt. Anchored on this principle, not guilty or acquittal are constitutionally required labels to which a person is entitled when the government does not meet the burden of proof. I'm not guilty. I was acquitted. That happened. So, you can invoke that for your own protection, just as surely as the government would like to invoke guilty for their protection. So, it kind of goes both ways. And it follows when the government violates the Constitution when it denigrates the label and its accompanying protection by using it as part of a body of proof the person's alleged misconduct in a subsequent case. So yeah, you were found not guilty, But that makes you all the more guilty because you were so you were so emboldened by your not guilty acquittal verdict that made you all the more an attacker. So once acquitted, twice criminal, I guess. I don't know. For these reasons, the court-martial judge clearly abused discretion in allowing the government to introduce evidence regarding the prior victim in the prior case to which there was an acquittal already. We do not mean to suggest as a general principle evidence of prior acquittal is always barred. Rather, we only hold that military judge erred in this case in finding evidence was admissible to show that this emboldened the applicant. So yeah, you can't use it for that argument. You're trying to use it to his state of mind, right? The reason you said it was admissible is to his state of mind. It emboldened him. It went to his state of mind, and the court's like, yeah, no, we don't think so. Not so much, no. In addition, the court-martial judge also did not exercise great sensitivity in addressing this evidence. Instead, by specifically affirming the government's misguided argument that the acquittal emboldened the appellant's tactics, this evidence as written finding the factor weighs in favor of admissibility. The military judge gave insufficient weight to guiding principles of case law that require the great sensitivity that they didn't demonstrate. Likewise, by allowing the government to argue the appellant learned from his mistakes after being acquitted, the implication that the first panel got it wrong, arguing they didn't believe the victim. So showing a lot of respect for that prior military jury over here, right? Showing a lot of respect for that prior military jury. And the fact that the appellant had previously been court-martialed for the assault defeats any mistake of fact defense in this case. The military judge did not deal with the evidence very carefully. So, yeah, there's that. The military judge who did the court-martial also did not instruct the panel of the necessity to consciously limit consideration of acquittal evidence. As noted above, the military judge only gave the standard military judge's bench book instruction, with 2 additional sentences indicating appellant was acquitted of the prior offense, and the panel should consider the result from the prior court-martial, which said, not guilty, but is not binding on you. Which I'm not sure why it isn't, incidentally. Why is not guilty binding on them? Why wouldn't it be? Isn't that res judicata? I mean, it's just a base principle. Once decided, an issue once decided, is sort of binding, sort of by its nature on future courts, and because we don't relitigate things over and over and over again. So once a decision is made, like res judicata, the thing has been decided. But apparently, how about would you like to come to a different decision? New panel. We'll just keep trying until one of you panels agrees that the first victim was in fact victimized. As noted above, the military judge who did the court-martial only gave the standard instruction. In sum, given this deficient instruction, combined with the written and evidentiary rulings, the court-martial judge abused discretion by not treating the acquittal evidence with required care and sensitivity. For the same reasons as discussed above about the acquittal evidence and how it may not be used, we also found that the prosecutor's argument was in plain error. So the prosecutor did a bad because, they made improper arguments to the jury. There are rules, sir. And, you made improper arguments to the jury. So that acquittal that you used to try to convict them, yeah. That's a problem. We see no logical or legally permissible connection between the fact the appellant was found not guilty and the notion that he learned how to commit additional misconduct. Moreover, we find the government collectively apply this logic to all of the allegations. So it makes everything more likely, don't you know? It makes all of it makes him more universally a criminal. The fact that he got away with it makes him more universally a criminal across the board. Similarly, we see no permissible connection between a fact of a previous trial, which was guaranteed by the Constitution, and the prosecution's specific argument it rendered a reasonable mistake of fact defense as the victim too unpersuasive. The rationale turned appellant's due process shield into a sword, and we are far from convinced that it resulted in new prejudice. So yes, this is a mistake that matters. We think it prejudiced the result. We think you using their acquittal as an argument that makes them all the more guilty is a problem. We are also perplexed by another part of the assistant trial counsel assertion of the similarities between the evidence. How this was even arguably relevant is beyond us, because what the assistant argument argued was that several of the victims are women of color. So assistant prosecutor over here says, okay, he's guilty because all the women he's accused of assaulting are women of color. And the Court of Appeals for the Army is over here like, what? How this is even arguably relevant is beyond us. After pointing out for the record that the appellant is black, the defense aptly noted such comparisons are not made when white persons are involved. So also your argument was racist. Because, you know, if a white person sexually assaults white people, you wouldn't make the argument that the victims are all like white. So this is a black suspect who apparently or allegedly attacked some black women, and you're like, oh, he's ever the more guilty because his victims are women of color. And the Court of Appeals over here is like, that's pretty racist, because you wouldn't make that allegation if the races were the other way around. You're only making that argument because they're black. You wouldn't make the argument because they're white. And so, you know, if you don't do it both ways, it's kind of racist. So maybe less with the racism next time. That would be great. Thus, that brings us to the end of this case for the Court of Appeals for the Army as it relates to a court-martial. A guy has been court-martialed a couple different times. Not to success, it seems. The U.S. government having a difficult time with the court-martial, which, you know, is kind of hard to screw up, particularly because you only need, like, what, 3/4 of the panel to agree to guilt? So you don't even need a unanimous jury, at least in the military system. So they couldn't even get a guilty verdict, even though they don't need unanimity. That's how well it's going for the. So they keep trying to court-martial this guy for the sexual assaults, and the first jury is over here like, you know, well, you know, this victim, they're a prodigy. They're taking college level courses. They've got some sort of grant from NASA. They're a bright person. They were assaulted. They went immediately to their mom. They got the rape kit done right away and everything. But you know what? We just don't buy it. We don't buy it. How about acquittal? How about acquittal? And the government is sad. The government is sad because, you know, acquittal. Now he's charged with a different crime. How about the 15-year-old derelict with the alcohol problems? Oh, the reason he chose this victim was he was emboldened by his acquittal. The fact of his acquittal means that he was re-enriched in his desire for the assault, and he picked a victim that would be less likely to be believed, so he wouldn't run that pesky risk of conviction again. How about we use the acquittal again? How about we have the woman testify from the previous trial in this trial that he was already acquitted of? But, you know, how about you, jury? Maybe you will believe it because you're not bound by that other jury. And the Court of Appeals for the Army over here is like, you know, no. Not so much with that conviction. So not so much with that court-martial either. So the Army not really good at the court-martialing as it relates to this particular member of the Army. So I don't know. Get better, I guess. And at least for the moment, that brings us to the end of discussion of this story.